Number 4, statement of personal or family history. Number 4, this is page 22, Colorado Rules of Evidence Handbook, Common Objections, Evidentiary Foundations, 2021. Professor John Bar Kai and Turner Wong. Statement of personal or family history. A statement concerning the declarant's own birth, adoption, marriage, divorce, legitimacy, relationship by birth, adoption, or marriage, ancestry, or other similar fact of personal or family history, even though declarant had no means of acquiring personal knowledge of the matter stated. Or B, a statement concerning the foregoing matters and death also of another person if the declarant was related to the other by blood, adoption, or marriage, or was so intimately associated with the other's family as to be likely to have accurate information concerning the matter declared. Number 5, transferred to Rule 807, Rule 805. Hearsay within hearsay. Hearsay included within hearsay is not excluded under the hearsay rule if each part of the combined statements conforms with an exception to the hearsay rule provided in these rules. Rule 806, attacking and supporting credibility of declarant when a hearsay statement or a statement defined in Rule 801 D2 C, D, or E has been admitted into evidence. The credibility of the declarant may be attacked, and if attacked, may be supported by any evidence which would be admissible for those purposes if declarant had testified as a witness. Evidence of a statement or conduct by the declarant at any time inconsistent with his hearsay statement is not subject to any requirement that he may have been afforded an opportunity to deny or explain if the party against whom a hearsay statement has been admitted calls the declarant as a witness. The party is entitled to examine him on the statement as if under cross-examination. Rule 807, residual exception. A statement not specifically covered by Rule 803 or 804 but having equivalent circumstantial guarantees of trustworthiness is not excluded by the hearsay rule. If the court determines that A, the statement is offered as evidence of a material fact, B, the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts, and C, the general purposes of these rules in the interest of justice will best be served by admission of the statement into evidence. However, a statement may not be admitted under this exception unless the proponent of it makes known to the adverse party sufficiently in advance of the trial or hearing to provide the adverse party with a fair opportunity to prepare to meet it, the proponent's intention to offer the statement, and the particulars of it, including the name and address of the declarant. Rule 901, requirement of authentication or identification. A, general provision. That's Article 9, authentication and identification. A, general provision. A, general provision. The requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. B, illustrations. By way of illustration only, and not by way of limitation, the following are examples of authentication or identification conforming with the requirements of this rule. Number 1, testimony of witness with knowledge, testimony that a matter is what it is claimed to be. Number 2, non-expert opinion on handwriting. Non-expert opinion as to the genuineness of handwriting based upon familiarity not acquired for purposes of the litigation. 3, comparison by trier or expert witness. Comparison by the trier of fact or by expert witnesses with specimens which have been authenticated. 4, distinctive characteristics and the like. Appearance, content, substance, internal patterns, and other distinctive characteristics taken in conjunction with circumstances. 5, voice identification. Identification of a voice, whether heard or firsthand or through mechanical or electronic transmission or recording by opinion based upon hearing the voice at any time under circumstances connecting it with the alleged speaker. 6, telephone conversations. Telephone conversations by evidence that a call was made to the number assigned at the time by the telephone company to a particular person or business. If A, In the case of a person, circumstances, including self-identification, show the person answering to be the one called, or B, in the case of business, the call was made to a place of business and the conversation related to business reasonably transacted over the telephone. 7. Public records or reports, evidence that a writing authorized by law to be recorded or filed, and in fact recorded or filed in a public office, or a purported public record, report, statement, or data compilation in any form is from the public office where items of this nature are kept. 8. Ancient documents or data compilation, evidence that a document or data compilation in any form A is in such condition as to create no suspicion concerning its authenticity. B, was in a place where it, if authentic, would likely be. And C, that was prepared before January 1st, 1998. That's effective July 1st, 2021. 9. Process or system, evidence describing a process or system used to produce a result and showing that the process or system produces an accurate result. 10. Methods provided by statute or rule, any method of authentication or identification provided by Colorado rules of procedure or by statute of the state of Colorado. Rule 902, self-authentication. Extrinsic evidence of authenticity as a condition precedent to admissibility is not required with respect to the following. Number 1, domestic public documents under seal. A document bearing a seal purporting to be that of the United States or of any state, district, commonwealth, territory, insular possession thereof, or the Panama Canal Zone, or the trust territory of the Pacific Islands, or of a political subdivision, department, office, or agency thereof, and a signature purporting to be an attestation or execution. Number 2, domestic public documents not under seal. A document purporting to bear the signature in his official capacity of an officer or employee in any entity included in paragraph 1 hereof having no seal. If a public officer having a seal and having official duties in the district or political subdivision of the officer or employee certifies under seal that the signer has the official capacity and that the signature is genuine. 3. Foreign public documents. A document purporting to be executed or attested in his official capacity by a person authorized by the laws of a foreign country to make the execution or attestation and accompanied by a final certification as to the genuineness of signature and official position, A, of the executing or attesting person, or B, of any foreign official whose certificate of genuineness of signature and official position relates to the execution or attestation or is in a chain of certificates of genuineness of signature and official position relating to the execution or attestation. A final certification may be made by a secretary of embassy or legation, consul, general consul, vice consul, or consular agent of the United States, or a diplomatic or consular official of the foreign country assigned or accredited to the United States. If reasonable opportunity has been given to all parties to investigate the authenticity and accuracy of official documents, the court may, for good cause shown, order that they be treated as presumptively authentic without final certification, or permit them to be evidenced by an attested summary with or without final certification. With or without final certification. With or without final certification. Number 4, certified copies of public records. A copy of an official record or report or entry therein of a document authorized by law to be recorded or filed and actually recorded or filed in a public office, including data compilations in any form certified as correct by the custodian or other person authorized to make the certification by a certificate complying with paragraph 1, 2, or 3 of this rule, or complying with any federal or Colorado rule of procedure, with any federal or Colorado rule of procedure, or with any act of the United States Congress, or any statute of the state of Colorado. Number 5, official publications, books, pamphlets, or other publications purporting to be issued by the public authority. 6, newspapers and periodicals, printed materials purporting to be newspapers or periodicals. 7, trade inscriptions and the like. Trade inscriptions and the like. Inscriptions, signs, tags, or labels purporting to have been affixed in the course of business and indicating ownership, control, or origin. 8, acknowledged documents. Acknowledged documents. Documents accompanied by a certificate of acknowledgement executed in the manner provided by law by a notary public or other officer authorized by law to take acknowledgments. 9, commercial paper and related documents. Commercial paper, signatures thereon, and documents relating thereto to the extent provided by general commercial law. 10, presumptions under legislative act. Any It's the Call of the Wild. That's why I listen to it. So where was I? Did I finish it? I think so. 8, acknowledged documents. Documents accompanied by a certificate of acknowledgement executed in the manner provided by law by notary public or other officer authorized by law to take acknowledgments. Excuse me, ma'am. Can you take acknowledgments? I sure cannot. And get the hell out of here. Number 9, commercial paper and related documents. Commercial paper, signatures thereon, and documents relating thereto to the extent provided by general commercial law. 10, presumptions under legislative act. Any signature, document, or other matter declared by act of the Congress of the United States or by the statute of the state of Colorado to be presumptively or prima facie genuine or authentic. Prima facie is on its face. On the surface, on its face, it's true. It's a video. It don't need to have any authentication or foundation. 11, certified domestic records of regularly conducted activity. The original or a duplicate of a domestic record of regularly conducted activity that would be admissible under Rule 8036. Rule 8036, which was, what was that? Go ahead. 8036. It's not the hearsay rule. Or is it? Is it the hearsay rule? It is. Records of regularly conducted activity. If accompanied by an affidavit of its custodian or other qualified person in a manner complying with other Colorado statute or rule prescribed by the Colorado Supreme Court, certifying that the record A was made at or near the time of the occurrence of the matters set forth by or from information transmitted by a person with knowledge of those matters. B was kept in the course of the regularly conducted activity, and C was made by the regularly conducted activity as a regular practice. A party intending to offer a record into evidence under this paragraph must provide written notice of that intention to all adverse parties and must make the record an affidavit available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge them. 12. Certified foreign records of regularly conducted activity in a civil case, the original or a duplicate of a foreign record of regularly conducted activity that would be admissible under Rule 803.6 if accompanied by a written declaration by its custodian or other qualified person certifying that the record A. was made at or near the time of the occurrence of the matters set forth by or from information transmitted by a person with the knowledge of those matters. B. was kept in the course of the regularly conducted activity. And C. was made by the regularly conducted activity as a regular practice. The declaration must be signed in a manner that, if falsely made, would subject the maker to criminal penalty under the laws of the country where the declaration is signed. A party intending to offer a record into evidence under this paragraph must provide written notice of that intention to all adverse parties and must make the record and declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge him. With a fair opportunity to challenge him. With a fair opportunity to challenge them.